Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class on Sunday, doing a little makeup. And this will be our final reading of a Zerohedge article, which is titled, "What If the America You Pledge Allegiance to Isn't the One Running the Show? The Corporate Veil, America's Hidden Transformation." And we left off down here a ways, getting into examining the evidence. And to go along with this series of classes, the mega file that you'll be able to download, and it'll be in all the show notes, so it's just an easy click. What I have in there for everyone is some extended information regarding the unlawful 14th Amendment, because it was given lip service in the article, but it wasn't really explained, or at least not to the extent that I have collected information regarding what really happened with the unlawful 14th Amendment. So there's quite a few articles and congressional record within that particular folder, which you're all welcome to download and share with everybody. Also in there is the Vocational Science Freedom Timeline Doc, which we've been looking at to cross-reference, and the Expatriation Act will also be in there. The 1871 creation of the District of Columbia, directly out of the congressional record, is in there if anybody wants to read that, and also pass it on for anybody who doesn't believe that the United States is now a federal corporation. Another document that I'm not exactly sure where I got this from, but it's called The Case for Secession of the States. It talks about a lot of what happened during the Civil War, and it makes the argument that they had the right to secede and the legality of it. I believe it's a law document. And then there's just the other things that just from the VSOF that everybody can download, which will also be, they're also in the main VSOF mega file. Memberships, correction status, suggested playlist for everybody that might be new to the VSOF, and the welcome package, which allows you to then set up communications with the VSOF and join not only our mega group, but also join our Revolt server. So with that, let's get back to where we left off here and at examining the evidence. So if we apply the approach Mark Schieffer outlined in the pattern recognition era, we should look for consistent patterns across multiple sources rather than relying on single authorities. True. Whenever you're trying to track any of this insanity down, it's always best to find the original source if you can. And if that's a case holding, so be it. If that's part of the congressional record, so be it. If it's simply the best text you can find on a subject, which is usually a treatise, but not always, or if it's a law review, these are the things that you want to search for first and know that you have your facts correct in no matter what you're looking up regarding law, not even just the corporate state aspect. But to continue. All right, so when we examine the historical records surrounding the 1871 Act and subsequent financial developments, several patterns emerge. Legal transformation. The congressional record and legal texts from the period show a marked shift in how the United States was described in legal documents before and after 1871. The appearance of United States in all capital letters, the format typically used for corporations in legal documents, also for dead things, becomes increasingly common after this period. Makes sense, because that's when they created the creature. And to make a point here, the correct name of the republic, the Confederacy, if you will, is literally stated in the first line of the Articles of Confederation. And it says, "This Confederation shall be styled the United States of America." That's the proper name of the republic. Okay. The documented timeline of these transformations reveals a methodical implementation. 1861 to 1865 was the American Civil War. Creates extraordinary financial pressures that some researchers believe provided the crisis necessary to fundamentally alter the nation's structure. Yes, that is probably an understatement after you get into all of the rest of the Reconstruction Acts and what they did, get into the Executive Order 100, which was the Lieber Code, and which placed pretty much all of the states, not just the southern states, under martial law, and everything else that goes along with the Reconstruction Acts. There is a lot there. I'm not going to try and cover all of that. I will touch on some of the other things in the VSOF timeline, though, just here in a minute. So 1862, Internal Revenue Service is established, initially as a temporary wartime measure, which is now chartered out of Puerto Rico. I don't believe it was immediately. I think it was chartered out of Delaware. And then 1866, the Civil Rights Act declares all persons, and again, a person is an infant, under 1 U.S.C. subsection 8, which we covered before, born in the U.S. to be citizens, meaning those subject to the jurisdiction of Congress, which some legal analysts interpret as converting natural rights into granted privileges within a corporate structure. That is exactly what happened. Civil rights are things that are granted to you from a government. Unalienable rights are things that you have by nature and nature's God, as Jefferson put it in the Declaration of Independence. And you can trade one for the other, meaning you can downgrade and decide to take a civil right. However, if you do so, you are abstaining from standing upon your natural law right. Also, you move into different jurisdictions. So under natural law, you'd have the right to bring in a trespass of said natural right in a common law court of record. But when you're dealing with civil rights, because it's a matter of equity, because it's contractual, you get stuck into equity courts where the black robe priest of El will act like a chancellor and decide to create his own law. That's not where you want to be. So there is a substantive difference between civil rights and unalienable rights. All right, next one. 1871, the District of Columbia Organic Act recognizes Washington, D.C.'s governance using language consistent with corporate formation. True. 1902, the Pilgrim Society is founded in London and New York, creating an elite transatlantic network connecting financial interests across national boundaries. I'm going to click on this because I'm rather curious as to what this particular article might link to. Okay, whatever their link was apparently doesn't want to work. Okay, I don't have anything specific for the Pilgrim Society. However, what I do have for 1902 is Cecil Rhodes dies and Lord Alfred Milner took control of the Rhodes Trust. Yeah, because I think Milner was the one that founded the Pilgrim Society. He also founded a few other things, I believe, at that time. I believe there was something that Milner founded called Milner's Kindergarten. Very strange name to put to the type of organization that it was. But it was more or less these societies that were originally set up by Cecil Rhodes and then continued under Lord Alfred Milner. All of these societies are meant to bring America back under the control of London, of England, of the crown, basically. And that was pretty much what Cecil Rhodes' last will and testament was all about, was to, and if anybody doesn't know who Cecil Rhodes was, he was the mogul that got his money from Rothschild to start all of the diamond mines and gold mining in South Africa, basically De Beers. So when he died, he gave that money back to Rothschild, and then he set up the trusts, which is where you get the Rhodes Scholars from, right? So everybody that's a Rhodes Scholar, and the two that come to my mind right off the bat are Bill Clinton and Rachel Maddow. Anybody who's a Rhodes Scholar is 100% focused on making sure that America goes back under the power of fucking England. Okay? So if you ever come across a Rhodes Scholar, I don't care what their position is. I don't care what their job is. That's their goal. That's their focus. And Milner, Rhodes first, and then Milner to continue, created a lot of these other groups and societies to continue to perpetuate that takeover. All right, next one. 1913, the 16th Amendment establishes federal income taxation, providing a direct claim on citizens' productivity. Well, yes and no. The 16th Amendment, the Supreme Court has stated multiple times that the 16th Amendment did not give the government any new taxing powers. Okay, so what the hell are they actually doing? What they're doing is they're taxing their own employees. Because if you have a Social Security number, you are considered under the United States Code to be what's called federal personnel. So all they're doing is they're taxing their own employees. They're not technically taxing sovereign people. And it's contractual because probably your mother or your father set you up, literally, and entered you into the Social Security contract before you had come of full age. So you were an infant when it happened. And all contracts that are created for infants technically do not continue to be valid once the infant comes of full age, unless that infant decides to continue the contract, either it be performance or whatever, which is exactly how they have this entire system set up with Social Security. And the other thing I wanted to mention about Social Security, if you really want to understand what Social Security is, look up the word tontine and do yourself a favor and do a deep dive. Maybe take a whole day to do it and delve into what the word tontine is, as in tontine Ponzi scheme. There have even been documents written. One of them comes to the top of my head was called the Tontine Government, which was literally talking about Social Security. It was a type of Ponzi scheme that was going on in the late 1800s. And they decided to run a whole government off it. Literally. And I know that sounds shocking, but there's a lot of other things in this article that are just as shocking, if not more so than that. So, yeah. 1913, Federal Reserve Act creates a central banking system, a privately owned entity with remarkable independence from public oversight, which we covered last few classes. Okay. I'm going to now shuffle through this. Okay, let's do this little transformation timeline as well, and then I'll go in and we'll check everything on the VSOF timeline doc. Okay, and I'm just going to make sure that this is closed so that everybody can see it clearly. All right, key events in the evolution of governance structures. 1666, which is not a bad place to start, but we could go back farther, to 1973. So 1666, Sester K. Vi Act, legal death presumption. Now, there had been several Sester K. Vi acts prior to 1666, but this is the one, if you go and read it, that one has to be found to be living in an action. So what the hell does that mean? It means that unless you've been proved to have been found to be living, and that's the exact way that you need to state it, which is how we do state it in our proof of life and proof of age inquests, which are at law, meaning common law, proper inquests in the vocational science freedom status doc set. We completely take care of and get rid of any of the presumptions of death under the Sester K. Vi Act or by any other means or jurisdictions of that presumption. Because I had to go back into history and realize how they did it in England back then. And it was done in a court named the Court of Wards and Liveries. And that's where infants, young men, had to go into this court and literally what was called sue out their livery. And literally they were suing their guardians for their estate. The rights of title, land, whatnot, whatever. Even their rights in and of themselves, right? That you have the right to XYZ, being a citizen of England, subject of the Queen, of course, but whatnot, of the Crown. But it was a whole court that you did this process in. Okay, so where's that court here in America? The answer is there isn't one. We have to make one. Meaning we have to make a court of record, and then we have to do these things and rebut these presumptions that are stated within the Sester K. Vi Act properly, at law within our sovereign capacity, which, again, is exactly what we do in the proof of life and proof of age inquest in the vocational science freedom status doc set. Okay, so that's the SFK-VI Act. So then they skip ahead, obviously, through a lot of time here. And some of the things that they skip through here are also very important regarding this whole aspect of corporate governance. Let me pull up the timeline class again. So in between this huge span of time here, you had the charterability, or the chartering, I should say, of all the colonies. See, what the Crown did is they chartered corporations to literally come over here and basically conquer this continent. And they had all kinds of different names, like the Massachusetts Bay Company, the Virginia Company, and so on and so forth. And corporations were what the norm of governance was over here prior to the Revolution, and it wasn't very nice. And we're kind of seeing that now, of what it's like to be being run by a corporation. And of course, the dreaded courts at that time in the colonies were obviously the maritime admiralty courts. Why? Because they were running everybody through those courts because it was all a matter of commerce. Well, they kind of liked that system. And particularly the turbo-Luciferian dark occult fools that ran the Bank of England, namely the Rothschilds. They liked to do business like that. It was easy. Just consider everybody a human resource. It's funny how that term came back into existence in the 40s and 50s, because prior to those times, you didn't have human resource departments in corporations. You had personnel departments. Well, that changed because corporations will always see you as a resource. So there's a lot more else to cut into this. I could go back up, but I don't want to make tonight's class too long. So on to the next one. All right, so the Civil War happened, financial crisis and debt, along with the Reconstruction Acts. 1862, IRS established, temporary wartime measure. Temporary is always in quote. 1871, DC Organic Act. That's the creature, municipal corporation, United States. 1886, Santa Clara County corporate personhood. That was the case that was made to the Supreme Court to say, oh, corporations are persons. Then 1913, Federal Reserve, which we covered ad nauseum in the last several classes, so I'm not going to rehash that. 1914 to 1918, World War I. This was their first major goal accomplished, was a world war. Because no one profits or is bettered by wars except the international dark occult bankers. That's it. Those are the only people that profit. The only people that do better afterwards and during are them. Maybe some industrialists for a short period of time, unless, of course, their industries are blown up, which happened more in World War II than World War I. But the other real reason for world wars is to have mass genocide, particularly of white populations. So they accomplished that pretty well in World War I. Next one, 1920, independent treasury. 1929, the Great Depression happened. This is obviously was created by the Jew bankers. Gold confiscation. This was done by Roosevelt, Executive Order 6102, which I literally read most of a few classes ago. 1935, Social Security. This is where they turned everybody into federal employees if you were dumb enough to enter into the contract. Erie Railroad decision. This is where the common law transformation happened. Not necessarily transformation, but they figured that, okay, if enough people are discharging their debts instead of actually paying for them, which is what's required under the Constitution to actually be at law, being under common law, that you have to not discharge debt, but pay it, either gold and silver, because no state shall make anything but gold and silver a tentative payment of debt, so on and so forth. And technically, all of us, being sovereign people, are also sovereign states. Now, do I mean that we're like New York? No. Or Wisconsin? No. I mean a sovereign state of being. That you are in a sovereign state of being. Okay? So when you're in your proper sovereign state, which, by the way, not to make too fine a point on it, is exactly the way that is the definition of state within the Second Amendment. The definition of state in the Second Amendment, where it says necessary for a free state, that does not mean, again, New York, Virginia, any of it. That means a sovereign state of being. That means that you can have the right to defend your sovereignty in your sovereign state of being of anyone who comes upon you that attempts to trespass, steal, harm, whatever. You have the right to defend yourself and to keep and bear arms for that reason. Okay? So again, getting back to the common law thing, that's where the problem of the transition where everybody's using the wrong money, more or less. That's why Erie Railroad was even able to be decided in the way that it was. Then World War II, again, Ibid with World War I. 1944, Bretton Woods Agreement, dollar is the world reserve currency. 1956, birth certificate, standard filing system. Okay, this might have been when they standardized the system, the filing system, but I believe the first birth certificates were started long before that. Now, if anybody wants to, they could probably just search the VSOF timeline doc and just search for birth certificate. You'll get every single passage that's in there. I believe it was prior to them setting up their fun little bank up here in 1913. They had to begin to be able to register people, children, and it was originally set up as a way for single mothers to quote unquote register their children so that they could get benefits from the corporate state for being a single mother. That was the original idea. You're like, hey, you poor people, you can get your benefits. And again, remember what I told about the difference between civil rights and unalienable rights? Well, taking a benefit is exactly the same idea. If you're taking a benefit, you owe a duty to who's ever giving it to you. So that is what wrapped everybody up. So, but the standard filing system didn't happen until 1956. And then 71, gold standard end. This is complete dollar gold separation. And technically, Nixon said, oh, it's temporary. Well, nothing that's been going on this long is temporary. And then 1973, the petrodollar, oil traded exclusively in US dollars, which also now brings us to all kinds of other problems in our current situation in 2025, but won't get into that at the moment. Okay, now let's scroll back and take a look at some of the things that might be of importance in the timeline doc. 1912 and 1913, banking history, Federal Reserve. We covered that. I covered the quote from House, along with the class that everybody I suggest watch on Mandel House. All right, so 13, bank history, March 4th. Wilson is elected 28th president, United States. Shortly after he's inaugurated. Okay, yep, I covered this before with Samuel Untermeyer basically blackmailing him and then forcing him to put in a Supreme Court justice when he came to him and said, this is the one we want put in. February 25th, Secretary of State Knox falsely and fraudulently certified that the 16th Amendment to the Constitution had been lawfully ratified. It should be noticed that the 16th Amendment did not repeal those restrictions imposed upon the United States by Article 1, Section 2, Clause 3, or Article 1, Section 8, Clause 1. Pursuant to those directives of Article 5, even if it were valid by having been properly ratified, which it wasn't. And technically, you can consider every single quote-unquote amendment after the original 14th to not have been properly ratified based upon the arguments that you'll be able to find within the documentation of the 14th Amendment, and that the southern states have been denied of suffrage ever since the Civil War. And so technically, it's all a facade since that time. But to continue. All right, so the 16th Amendment article amended absolutely nothing pertaining to the several states or the inhabitants thereof. The Congress, being well aware of these facts, never enabled the 16th Amendment as public law by appropriate legislation. And I don't know if I covered this yet in this class reading, but what they're getting at here is that in order to enable an amendment as public law and by appropriate legislation, not only does it have to be placed in correctly with a proper enactment clause, but it also has to have corresponding law within the Code of Federal Regulations, also known as the CFR, not to be confused with the Council on Foreign Relations. That the CFR regarding law is that they write law as to what or how they're going to do X, Y, Z. So if the feds write a law and then say they don't properly enact it, or let's say they do properly enact it. Let's say it does have a proper enactment clause, so on and so forth. It gets passed. It's on the books. Okay. If it does not have corresponding CFR with it, then it's like having something written down that tells you to go build a house, but no one ever provides the blueprints. So when that happens, it doesn't really act as a law because there's no enforcement mechanism. There's nothing that tells the government or the agencies thereof that are supposed to be doing whatever with XYZ law, doesn't tell them what to do. So it becomes basically like a nullity. And there's a lot of that nullity in quote unquote US law. But I just want to make a point of that. Okay, to continue. That in the amendment that did not repeal the aforesaid restrictions. And the Internal Revenue Code, Title 26 of the United States Code, which is predicated upon the 16th Amendment, is now and always has been private law, precisely, based upon public commercial contractual law. Also true. I believe this whole entry I took out of the document USA, the Republic that no one lives in, I believe. Also another good set of classes that everybody should go watch. To continue, see Amendment 21, ratified December 5th, 1933, for the construction of a repeal, sedition by syntax. Public does not mean private. True. More than often, public commercial law has been called quote-unquote public law, where it is in fact public commercial law regulating private commercial contracts and interests in equity and contractual performance made within the Admiralty jurisdiction. Also true. That is a very verbose sentence with a lot of highly packed vocabulary. I don't have the time to go through all of that. Those of you that have been in the VSOF for a while would probably know exactly what that sentence means, but I don't have time to break it all down. So I'll just keep going. True public law requires a harm. Also true. And differs from public policy. Public policy is what is used to control the heading of the United States citizens. Since the Geneva Conventions, meeting places of corporate council of 1864 and again 1929, the United States as a whole and individually known as citizens has been held under rules of war with merchant laws and laws of equity and maintained by corporate governance, unlawfully and through fraudulent assignment of birth, that each child born of the United States incorporated by charterability, which has allowed administration of each individual citizen through legal process contrary to public laws. United States Incorporated is a corporate enterprise and political subdivision as defined in 28 U.S.C. 1603. All right. April 8th, the several states presumably voluntarily surrendered and consented to deprive themselves of their rights of suffrage by the imposition of the 17th Article Amendment to the Constitution. Such amendment being an abrogation of the intent, directive, legal construction, and relevant structural conditions set forth in Article 1, Section 3, and in Article 5, providing that no state, without its consent, and that's the important part, shall be deprived of its equal suffrage in the Senate. It should be noted that when the people of the several states chartered the United States as an admiralty jurisdiction, it was not the legislative intent of the September 1787 Congress to put into effect a self-destructive mechanism, such as would possibly make a proposed constitutional amendment to the several states where, upon its ratification through any mechanism, the constitutional prohibitions regulating the United States would somehow cease to exist. This is true. And this is the aspect where the states no longer have the capacity to send in their own senators, right? They're now hired. Yeah, that was a Freudian slip. Voted into by popular election. Well, that's not the way it's supposed to be. The way it's supposed to be is that the state houses, the state legislatures, are supposed to vote on their own senators to send to Washington. And then the Senate is supposed to represent the power of the states, and the House of Representatives is supposed to represent the power of the people as a whole. But after that, it ceased to be that. All right. Timeline of the Federal Reserve Act. I think we covered most of this, so I'm not going to skip through that. However, I will go down to just skip down to the bottom here. So some recent evidence has come forward who really owns the Federal Reserve, and they are the following banks. Notice the names here. Rothschild Bank of London, Warburg Bank of Hamburg, Rothschild Bank of Berlin, Lehman Brothers of New York, Lazard Brothers of Paris, Kuhn Loeb Bank of New York, Israel Moses Schiff Banks of Italy, Goldman Sachs of New York, Warburg Bank of Amsterdam, Chase Manhattan Bank of New York. All of these are Rothschild banks. Yes, indeed. Or connected in there too. And let me see if there's anything else stretched into, well, this is kind of important. I'm not going to read all this, but April 25th, the Congressional Record was spoken of and warned about by a few in Congress, the secret Treaty of Verona, which happened in November 22nd, 1822. Obviously quite a ways beforehand, but it's an interesting thing to get into, but it's not necessarily pertinent to corporate governance. I'm going to skip it. Yes, this was when the Ashkenazi Jew Louis Dimbitz Brandeis, is appointed to the Supreme Court by the President Wilson as per his agreed blackmail payment to Samuel Untermeyer, which I spoke about before. By the way, again, these passages that say CUL, these stand for the Council of Uniform Laws, which is basically a monstrosity that was created out of Chicago, which now has a different name. And basically a pack of filthy attorneys just continued to decide to change state laws to make them, quote unquote, uniform, basically to perpetuate the rest of this fraud so that, one, they didn't really have to learn any new law from state to state, and two, that all of this fuckery flowed much easier between all of them. 1917 Balfour Declaration. We should all know what that's about, but not dealing with corporate governance. Banking history. Once in control of the monetary system, the Federal Reserve increased the monetary supply exponentially, causing the Roaring Twenties. They built the House of Cards, and on October 29th, 1933, they collapsed it deliberately. This enabled them to put thousands of competitors out of business, allowed them to buy commodities, land, and labor for dirt cheap, and manipulate the value of the dollar to their benefit. It wouldn't be exaggerating to say that the entire reason for their creation of the Federal Reserve creature was to do exactly this, which is the argument that Jackson made in several occasions, but talking about that there are a den of vipers, that when all of you took the profits, you shared them amongst yourselves, and when you had losses, you put it upon the backs of the people. Well, there you go. 1919 League of Nations, which never quite took off. 1921 Council on Foreign Relations was founded. That's an interesting point right around this time. Oh, okay, here we go. 1921, the Maternity Act. So I thought this was earlier than this. The beginning of mandatory birth certificates for U.S. slaves. This act was eventually repealed, but parts of it are still in effect in other statutes. The Federal Shepherd-Towner Maternity Act, yeah, that's the correct name of it, created the birth registration, or what we now know as the birth certificate. Okay, so that says 1921. The article says, the Zerohedge article says 1956, so there must be something else later. But anyway, I'll go ahead and read this out. It was known that the Maternity Act was sold to American people as a law that would reduce maternal and infant mortality. How the hell did they sell that based on a certificate? Anyway, protect the health of mothers and infants, and for quote-unquote other purposes. One of those other purposes provided for the establishment of a federal bureau designed to cooperate with state agencies in overseeing of its operations and expenditures. What it really did was create a federal birth registry, which exists today, creating federal children. This government, under the doctrine of parents patriae, now legislates for American children as if they are owned by the federal government. True. Through the public school enrollment process and continuing licensing requirements for most aspects of daily life, these children grow up to be adults. Well, that's debatable. Indoctrinated into the process of asking for permission from Big Daddy government to do all those things necessary to carry out daily activities that exist in what is called a free country. Before 1921, the records of births and names of children were entered into family Bibles. A good point and a good practice that everybody should continue to do, by the way, because those are the records of your house. They are not federal records, nor are they state records. And we also have processes at the VSOF, which, thanks to one VSOF lifetime member, Amaru, who created his own birth records for his child and then went and then recorded them onto the county records. Now, that's recording, that's not registering. And he's never had a problem with the county or the state since regarding anything that he does with that child. So he had his status docs done prior to him having his child, and then he made sure to record said document of his own private house records of the birth onto the county and give them notice and say, hey, this happened. Just telling you that you have no jurisdiction over it, meaning the issue, the child. All right, to continue. So since 1921, the American people have been registering their births and names of their children with the government of the state of which they were born, even though there is no federal law requiring it. Exactly. The state tells you that registering your child's birth through the birth certificate serves as proof that she was born in the United States, thereby making him or her a United States citizen. For the past several years, a Social Security number has been mandated by the federal government to be issued at birth. And we covered before about how the state governors committed treason in 1933, went to Roosevelt and pledged all of the registered property on the state side to the feds for loans to continue to be taken out from a private cartel known as the Federal Reserve. Okay, I'm going to get back to the article because everybody's welcome to take as much time as they want to in the VSOF timeline doc, but I just want to make sure that we get through the article tonight. Okay, so next section. Each of these developments documented in congressional records and primary sources represents a distinct step away from the constitutional republic established by the founders toward a system of features more consistent with corporate management than self-governance. That's an understatement. Financial control. Treasury Department records show that after the 1871 Act, America's national debt grew substantially and was increasingly held by international banking interests. Primary financial records from this period demonstrate how control over monetary policy gradually shifted from elected officials to private banking interests, culminating in the Federal Reserve Act of 1913. Global parallel development. Diplomatic archives reveal that similar corporate restructuring occurred in other nations during the same period, often following financial crises and always resulting in greater control by the international Jew banking interests. No surprise there, because this is the perpetuation of their one world government. They have to have world monetary control first before you can have a one world government. So this is the modus operandi of what they have done to every single country, for the exception of the few that will not take a central bank, which Bush Sr. determined to be the axis of evil. For all of you remember that. It was just all the countries that didn't have a central bank. But I digress. To continue. Documentary discrepancies. When comparing the Constitution to subsequent legal frameworks, particularly the Uniform Commercial Code that now governs most commercial transactions, significant shifts in legal philosophy become apparent. Right, which is exactly what I was talking about, the difference between what jurisdiction do you want to be in? Do you want to be at law? Do you want to have title? Do you want to own something? Or do you want to be in equity? Do you want to have civil rights and have, you want to be a usufructuary? So you get to use the thing, but you don't actually own it because you gave it to Caesar. So choose a side, people, because there's only two sides. And you don't get to sit on the fence, by the way. There is no agnosticism when it comes to these issues. You're either at law and you own what you own, or you're an infant and you get to play in the sandbox and throw cat shit at each other. Now, it's up to you. I don't particularly care what any direction any particular man or woman decides to go. That is completely 100% up to you. But just know that they've stolen your will and stolen your state. But if you want to come to the VSOF, take it back, please do so. If not, have fun with your benefits. Legal scholars have determined how common law principles were gradually replaced by admiralty and commercial law concepts, also known as equity. Masonic connections. Ooh, this is interesting. Didn't think you'd go there. The historical record uncovers another intriguing element in this narrative. The Treaty of Washington, 1871 Wikipedia page shows images of both British and American signatories displaying what historians have identified as the Masonic hidden hand gesture. A specific pose where, and if nobody knows what this is, just think of Napoleon, like any painting of Napoleon, where one hand is tucked into the coat in a particular manner. Historical accounts confirm that Freemasonry was extremely influential among political elites of this period, which membership records showing a significant percentage of government officials belonging to Masonic lodges. This, to a discerning mind, cast doubt on whether negotiations were solely determined by publicly stated national interests, hinting at influential shared affiliations operating beneath the surface. Yes, obviously. All Masonry is Jewry. Period. Full stop. Don't believe me? Go look it up. As Walter Lippmann noticed in a quote I examined in, quote, The Information Factory, close quote, the conscious and intelligent manipulation of the organized habits and opinions of these masses is an important element in democratic society. Well, thank God we don't live in a democracy. Live in a constitutional republic. If you can keep it. One might reasonably interpret the observable changes in America's legal and financial structures after 1871 to be in service of the conscious and intelligent manipulation that Lippmann describes. Right. Also, the same language that Wilson stated in earlier classes about how an intellectual elite should run everything. Well, there you go. Despite months of research on this topic, crucial questions remain. The timing of the transformations described here suggests coordination, but the documentation stops short of proving intent. Well, said author, all you got to do is watch these classes and I'll fill you in. The identical obelisks in the three financial centers could be coincidental. Of course, they're not. Through the statistical probability seems low. And perhaps most puzzling, if these patterns truly represent a fundamental transformation in governance, why has this interpretation remained so thoroughly outside mainstream discourse? Well, just go watch the Edward Mandell House class, as suggested. That will explain it. Next section, addressing mainstream interpretations. While examining those historical patterns, I've carefully considered conventional explanations. Oh God, here we go. Financial historians like Charles Kindleberger and economic scholars like Ben Bernanke interpret central banking developments as necessary stabilization reforms that reduce economic volatility rather than as sovereignty transfers. Well, of course they'd say that. Everything that the dark Luciferian occultists do is always necessary. Of course. That's why they'll kill you if you don't go along with it. Because it's necessary. It's for your own good. Right? Like burning you at the stake as a heretic. Anyway. Administrative law experts such as Jerry Mashaw contend that bureaucratic expansion represented professionalization of governments rather than constitutional restructuring. Tell me how government is supposed to be some sort of professional job there, Jerry? Pretty sure it was never meant to be that. And I'm pretty sure that to serve as a public servant and be a public trustee wasn't something that someone should have a job doing. But you can do that when you're actually working for a corporation and not an actual de jure government. So, pointing to continued democratic oversight through congressional budgeting and judicial review. Yeah, anyway. These interpretations make valid observations about individual developments. What's significant, however, isn't any single change, but the cumulative pattern and shared directionality of these transformations. Even conventional scholars acknowledge that these developments collectively altered the citizen-government relationship, although they disagree on whether these changes represent legitimate adaptations or concerning departures from founding principles. Well, I think we know which one of those is correct based upon everything that we've covered so far. For instance, economic historian Charles Goodhart argues that central banking followed a natural evolution. Anybody want to know the natural evolution of central banking? Go watch the documentary Money as Debt. That's Money as Debt. And I believe I have it re-uploaded on Odysee, but you can find that documentary anywhere. If you have not yet watched that, go watch Money as Debt to see the actual evolution of central banking. All right, based on practical financial needs rather than orchestrated design. We all know that's a lie. His detailed analysis of the Banks of England's development suggests that many centralized patterns emerged from crisis rather than from premeditated planning. Well, what the fuck do you think? Where do you think the crisis came from? Mother of God. Are we so stupid that we don't have pattern recognition? Like we're not human anymore? But apparently this man is going to argue that don't pay any attention to pattern recognition. Right. Oh, right. Which continues. While this doesn't invalidate the pattern recognition approach, really? It offers an alternative lens for interpreting the same historical events. No, sorry. Here, read the Vocational Science Freedom Timeline doc and then state that. You won't be able to. It's worth acknowledging that these transformations brought certain practical benefits. Reduced frequency in financial panics. Well, bullshit. They just became scientifically orchestrated panics whenever they felt like it. So that's an incorrect argument right there. Standardization of rights across jurisdictions. That we know is bullshit. It's an absolute stealing of all rights of the white people and then just turning all of the blacks from private property to being public property. And then stealing everybody's rights from the presumption of infancy and death. Anyway. And specialized expertise addressing complex challenges. Well, that's always the attorney's fucking excuse for changing and meddling and messing up and altering any aspect of law that they can't control. Well, it's just because it's all this expertise that you need. And only we can figure it out for you. The question isn't whether these changes brought any benefits, but whether citizens would have consented to these benefits had they been presented transparently rather than implemented incrementally over generations. That, my fellow sovereigns, is called boiling the frog. They have to do it slowly. If they did it all at once, we'd slaughter every single one of them. Without hesitation, mind you. Just like some Midwestern farmers did during the Great Depression when they strung up some judges in trees. Well, okay. They didn't quite get to the stringing. But they created the nooses and they paraded the judge out to the tree and were just about to hang him up. When a bunch of other men said, we can't do this. That's the kind of lynch mobs that I would prefer to see return under common law, because every single one of these people are thieves. And first offense under common law, people, for thievery is death by hanging. But to continue. Questions that demand answers. The evidence presented points to a pattern that cuts to the heart of our understanding of modern governance, citizenship, and sovereignty. What exactly happened in 1871? If the documented shift in legal language and court decisions genuinely reflected a transformation of America's fundamental nature, why isn't this taught in any standard history curriculum? Yeah, such a strange question to ask. I wonder, who writes all of the current curriculum books that are in the Prussian education system right now? Which is very glad that Trump wants to get rid of the Department of Education completely. And by the way, to answer the question, it's Israel. That's who writes the curriculum for the books that your children go through in school. Don't believe me? Follow the money. But to continue. The congressional record contains the full text of these debates. Why are they virtually unknown to most citizens? Well, nobody bothers to read anymore. Even more fundamentally, what is the nature of money itself in the system? Nothing but a debt note. As discussed earlier, Federal Reserve notes are explicitly labeled as notes, financial instruments representing debt, not assets. This creates a paradox we previously examined. How can a debt be satisfied with another debt? This monetary paradox represents a fundamental transformation that few citizens comprehend. When currency shifted from representing stored value to representing debt obligations, it fundamentally inverted economic relationships. Exactly. Credit River decision, also known as the Jerome Daly case. Very interesting case. Proved that Federal Reserve notes were worthless, and good old Jerome Daly got to keep his house and didn't repay fuck all to them. I have the whole case if anybody wants it. The Federal Reserve notes we use as money are by design instruments that create perpetual circulation of debt rather than exchange of value. Right, which is why you don't own anything, because you didn't actually pay for it. A system that requires continuous growth, not for prosperity's sake, but to service the expanding debt that forms our monetary foundation. This contradiction suggests that the entire financial system may operate on fundamentally different principles than what most citizens understand. Right, we covered that before. There have been More fiat currency systems than you can count. Well, you can count them. 1,364, some amount therein, across the entire planet that we've documented. Who knows what might have gone on or not gone on pre-Younger Dryas impact, but let's not go there for the moment. All right, to continue. Why the persistent symbolism? If the connection between the City of London, Vatican City, and Washington City is merely coincidental, why do these three centers display identical Egyptian obelisks? Why does documented imagery from the period when these governing structures were established contain consistent Masonic symbolism? Are we to believe these patterns represent mere aesthetic preferences rather than intentional communication? Why does this discussion get sidelined? Well, silenced as well. Perhaps most tellingly, why do discussions of these documented historical facts frequently face institutional resistance? When alternative interpretations of congressional records, court decisions, and Treasury documents are presented, they sometimes face dismissal rather than substantive engagement with this historical evidence and its potential implications. Remember what House said? And if one man in a million could figure it out, we will have in our arsenal plausible deniability. That's the reason, Mr. Author. Plausible deniability. If you just keep pushing it, they'll just say, oh, you're crazy. Throw you in a straitjacket, like Ezra Pound. All right, to continue. What would genuine sovereignty look like? If the evidence suggests our current system represents a form of managed or fiat sovereignty, what would a return to genuine self-governance require? Well, that's the reason why I created the Vocational Science of Freedom, so that everybody has a path to that exact goal. It's what the symbol represents. The entire symbol of the VSOF, the center circle, is the fact and understanding that you are sovereign. That's why there's an S there. And the other four quadrants are required for you to maintain your sovereignty. Self-reliance, self-awareness, self-governance, self-defense. We are the only organization in America that will teach people how to properly do this. No one else comes even close to answering this question for people. No one. And I've looked at every single other quote-unquote law guru that's out there, every other system that's out there. They're all missing fundamental things that need to be taken care of at law. None of them do it, except us. So if you want out, there's one way. And yes, we do continue to create new documents for whatever other problems might come along the road. But you're not going to get them from anyone else because they're based upon the original correct Vocational Science of Freedom status documents so that you can be self-governing, so that you can take your sovereignty back, and so that you can claim your estate back, which is exactly what used to happen, as I said, in the Court of Wards and Liveries. But seeing as how we didn't have a process, seeing as how we didn't have a court to do that, seeing as how no one wanted to give us remedy for what they were doing, I had to reverse engineer it over the last 30 years. Because, yeah, it takes that long. Because you have to figure out every single part of what they're doing. If you walked up to a car, you had absolutely no idea about how an internal combustion engine worked, how a transmission worked. You would have to sit there and slowly take apart that car. Literally lay out every single piece of that car onto a very large spread of probably white background, and then label it and probably give it names. You wouldn't know what these things are called. You'd say, this is such and such. This is such and such. But the attorney does this and says, well, this is such and such. Okay, but is that actually what it is? And the answer is no. So when you go to start deconstructing all of this fuckery from the analogy of doing the car, you're being told that the radiator is a spare tire. It's no wonder why no one can figure this out. Trust me, it wasn't easy. And I don't know what gift God gave me to be able to do it. Probably just persistence and a hell of a lot of attitude. But I did. And now people are on the do not detain list. There are people that do not get touched when they're going down the street. And there are people that are having their own children and they don't have to register them. There's one way out, people. One. But to continue, get off my soapbox. What specific changes to legal, financial, and governmental structures would restore the constitutional republic envisioned by American founders? Answer, you have to claim your estate back, or else you do not and will never be one of the members of the posterity spoken of in the preambles. You can't get there, people, when you're barred from your state. These questions aren't merely academic. They strike at the foundations of our social contract. Right. If the consent of the governed was indeed bypassed through legal mechanism that virtually no citizen understands, what does this mean for the legitimacy of our current system? That's a very good question. Answer is, there is none. The documents exist. The court decisions are recorded. The financial relationships are documented. What remains is for citizens to examine this evidence and draw their own conclusions about the nature of the system in which they live. Right. And correct it. From recognition to action. If the evidence persuades you that at least some aspects of our governance system operate in ways fundamentally different from what we're taught, what then? Here's a framework for consideration that moves individual awareness to collective action. Individual understanding. Document examination. Compare your legal documents with the Constitution, paying particular attention to terminology, capitalization, and numerical identifiers that might indicate registration as financial instruments. Also, if you want to start down this path, the first thing that you do is go download Bouvier's Law Dictionary. I would also suggest downloading a words and phrases book. Probably an older one would be better. And I would also highly suggest also downloading a Black's. I find Black's 7th edition deluxe and Black's 9th and 10th to be pretty good. You use Black's to track down, lock down the definitions of maritime admiralty words, equity, military, ecclesiastical, UCC, and you use Bouvier's for constitutionality, common law, natural law, and sovereignty. So you can kind of juxtapose the two of them. And you do want to read the definition of both words on both sides. Now, if you're strictly talking about the Constitution and the constitutional documents, then that's just all Bouvier's. Do not use Black's to try and decipher the Constitution. You would come to incorrect conclusions. Okay. But Bouvier's is specifically written for that reason. Okay. So next one. All right. Prime source research, examine court decisions, especially Hale versus Hinkle. Absolutely. Which distinguishes natural from legal personhood, congressional records, and treasury documents directly rather than relying on interpretations. Financial literacy, understand how monetary systems operate, how money is created, how national debt functions by studying primary sources like congressional debates on the Federal Reserve Act and gold standard transition. Community engagement, share this knowledge in local study groups and discussion forums that transcend traditional political divisions, focusing on constitutional provisions and common law traditions. That's what the VSOF is, everybody. You're all welcome to join for free. And on Wednesday nights, we have a hell of a time because there's no filter on Wednesday night roundtables, everyone. And they are not going to be put out to the public. But that's where we all get together on a regular basis, talk about our cases, talk about current events, just vent to our fellow American sovereigns, because it's important to have community. Okay. You are not alone. And as a wise man once said, no man is an island. So come and join us for free. And just to make a point about that, you can come to the Vocational Science of Freedom at vocationalscienceoffreedom.wordpress.com and make sure you click on the welcome package, and that will get you set up for joining the VSOF on Revolt and also on Mega. Because he's absolutely right. Community is extremely important. I was a lone wolf for a very, very long time. 20 years, 15. And then I said, you know what? I think I've reached the limit to what I can possibly figure out on my own. And then I went out and I sought mentors. And I found some pretty good ones, which helped me along the way. So that's my duty to now pass on to all of you to be the best mentor that I can for all of those that came before me. All right, next one. Systematic engagement. Support transparency initiatives regardless of political affiliation. True. Support transparency of what is going on. Bring people to the VSOF. Share the Vocational Science of Freedom classes. Certainly share this reading, because this is probably one of the best readings for completely new people that have really never looked at any of this at all. Very down to earth, open-ended, and then they get on top of it everything that they want to delve into regarding all of the classes that I've said to go watch, including the reading of the timeline doc. So, pursue legal clarity about the relationship between citizens and governance structures. Well, that is just the totality of the study of law. Because if you don't understand the totality of the study of law and you try and go at this, you're not going to quite understand what you're reading. Advocate for explicit disclosure when documents address your legal person versus natural person, meaning address your estate, because again, there's no separate corporation or thing. Most importantly, begin with your own documentation. Examine your driver's license, birth certificate, social security card, mortgage papers, and other official documents. Notice the capitalization patterns of your name, the specific legal terminology used, and how you are identified in these systems. All right, little pause here. The whole thing about, notice capitalization. Well, if you're older, they might not be capitalized. Or maybe just your last name is capitalized, particularly on birth certificates. I know several men, older men, whose birth certificates only their last name was capitalized. So just beware of that. And that also, again, for clarity, the name on the BC is the name of the estate as it was registered. I don't give a shit if it's in all caps. I don't care if it's in all lowercase. I don't care. I don't care if there's just an X there. I don't care. Whatever's on there is the name of the registration of the estate at birth, okay? So just know that. Okay. This personal examination requires no specific knowledge, just attention to detail and willingness to question the frameworks you've taken for granted. If these systems operate as described in this analysis, the evidence will be visible in the documents that define your relationship with the state. The path forward isn't about partisan politics, but about fundamental questions of consent and sovereignty. Indeed. Thomas Jefferson noted that an informed citizenry is the only true formation of free governance, I believe is what he said, not democratic governance. If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. If we are to reclaim our sovereignty, we must first take action to understand what is being done without our consent. By asking better questions about the nature of sovereignty, money, and citizenship, we begin the essential process of restoring genuine understanding, without which no governance system can truly claim legitimacy. Yeah, that's probably one of the most important paragraphs that this gentleman has written in this article. My own research has led me from casual interest in legal systems to deeper questions about governance, money, and identity. This historical investigation reveals the foundation upon which today's technological control mechanisms have been construed. The evidence clearly demonstrates that significant structural changes occurred in America's governance between 1871 and 1933. You can go back before that, but all you need to do is read the timeline. Reshaping the constitutional relationships that the founders established. These structural changes created an administrative state which now operates via digital systems that extend Wilson's vision of governance by experts into governance by algorithms. This is the technocratic state, by the way, everyone. There have been some pretty good documentaries specifically about this. One of them, let's see if I can recall the name of it. I think it's called All Watched Over by Machines of Love and Grace. I think. There's also another one out, which name I believe is just simply called Technocracy. I forget the subtitle. And then the interview that Richard Grove did with, I think his name was Bill Binney. He was either ex-CIA or was he CIA? I think he was CIA. If not, he was. I can't exactly. Yeah. Anyway, just look up Binney. Look for the interview, and he talks a lot about this aspect of the transformation and the being watched over, right, by machinery and the frameworks and the administration, and how it's getting more and more digital, and how dangerous that is, basically. So track down those three things if you want a far, far better understanding and pretty much like a complete overview of the aspect of this governance by algorithms, maintaining the same illusion of representation while further removing decisions from citizen influence. This whole part here. Basically, just in a short term, I just always call that technocracy. I don't know if the gentleman who created that documentary coined that term, but I think it's been around for quite a while, I would think. In ancient Greece, it's basically the allegory of the cave. To continue, as we pull back the curtain like Toto in The Wizard of Oz, we may discover that the governance system we assume to be legitimate is, in reality, nothing more than an elaborate legal illusion. One that persists only so long as we fail to recognize it, and only persists so long as we continue to give it legitimacy and our consent. Next section. Conclusion. Peering behind the curtain. The evidence presented in this analysis doesn't definitively prove a singular conspiracy to transform America from a constitutional republic to a corporate entity. Well, debatable. Rather, it documents a pattern of incremental changes in legal frameworks, financial systems, and administrative structures that, viewed comprehensively, suggest a profound shift in how governance operates. What can be established with certainty from primary sources includes 1. The language used to establish DC governance in 1871 employed corporate terminology distinct from the constitutional founding documents. 2. Supreme Court decisions increasingly distinguished between natural persons and legal entities throughout this period. 3. Monetary policy control shifted substantially from elected representatives to banking interests. It totally shifted. It was completely taken over. Number 4, administrative systems for citizens identification expanding in parallel with financial frameworks, right? Total registration of the births. Whether these developments represent pragmatic adaptations to modern governance challenges or a more fundamental transformation in sovereignty remains open to interpretation. Again, no, it doesn't. This is what they're doing to destroy America. This is what they're happening to also do for genocide, particularly white genocide. Black genocide as well, certainly through the aspect of family courts and Planned Parenthood. But to continue, what matters is recognizing that our current systems may operate on principles fundamentally different from what most citizens understand or have expressly consented to. Right. Because no one consents to any of this shit if they actually knew what was going on. Much like we routinely accept terms of service without reading them. Oh my God, isn't that a good point? Okay, right. You saved the banger for the end, folks. Have any of you actually read a user and license agreement for software? Like seriously read it, all of it, gone through it? I highly suggest that you do, because some of that shit is really dangerous. You give them all kinds of things. In fact, something that's even more dangerous, why don't you go look into user and license agreements regarding printers and people that set up these types of refill programs with these various different printer companies, and they say, yeah, we'll send you so much paper and we'll send you so much ink and we'll monitor how much ink and paper you use out of your printer. You want to know what else they're monitoring? They're scanning every single document that you put through your printer. Don't believe me? Go read the user and license agreement. It says they can do that. So yeah, that's a very, very important point. Okay, but to continue. We navigate governance systems without understanding their true parameters. Grab your own documents, share your findings, and let's collectively map this forest together. Good point. Whatever conclusions you draw, I hope it inspires the same curiosity and critical thinking that drove my own investigation. If this analysis resonates, consider advocating for greater transparency in modern policy, modern and monetary policy, supporting constitutional education initiatives, right, meaning getting rid of the entire Department of Education, or simply sharing these questions with others. The path to reclaiming genuine sovereignty begins with understanding the systems that currently govern our lives. And I would add our states as well. Okay. So that's the end of this article. And just again, it's what if the America you pledge your allegiance to isn't the one running the show, the corporate veil, America's hidden transformation. I have put the link to this article in the comment section of each platform. And again, you guys are all welcome to download and take a look at the VSOF timeline doc as much as you would like to. Just going to check chat real quick. Check Rumble chat. Yeah, United States of America. Yeah, we the people, we the sovereign people are the foundation of everything. So in a sense, yes, that does make us a creditor, and the United States of America, or the United States being a federal corporation and Congress being the one that is indebted to the international banking cartel, is the debtor side, because that's them and we are not subject to their debt, nor do we have to pay for it. And in Mega, Aloha said, question, where does the term fraud vitiates everything come from? And could that apply to dismantling the usurpations? The answer is yes. It's a maxim of law, and maxims of law exist from, I wouldn't say time immemorial, but maxims you can consider and use as arguments of law because they are such completely agreed upon truths in law that is what makes it a maxim. And the other reason about fraud destroys or vitiates everything is that there is no statute of limitations on fraud. That's why they hate that word. It's the most detrimental word to them that you could ever use. And yes, there's plenty of evidence also to suggest that all of this is fraudulent, clearly. I mean, there was no meeting of the minds of certainly the mothers, any of our mothers, I'm sure, to actually realize what they were doing at the time at the Foundling Hospital to register the birth. If they knew that they were abandoning their babies by document at the hospital, no one would do it. Because again, as he says in the end, the actual consent is based upon what's going on. You know, the path to reclaiming genuine sovereignty begins with understanding the systems that currently govern our lives. Yeah, maybe you might want to start reading contracts. Start reading licenses. That's a good point. Other question, is there a list somewhere of laws that don't have corresponding CFR? I don't know if anybody's made a total list of that as far as what is actually properly enacted public law and what is not. I don't know. So I don't have an answer for that, but that certainly would be an interesting research project. I've noticed when law gets a substantial rewrite, it will be common to only see the revised date and very difficult to find the original or an older version of a legal document. Yeah, particularly when they're messing around in statute. Janice, that's true. What you want to do when you're researching things like, say, federal law or state law, you want to go to the original acts, because then not only can you see if the original act, when it was passed, had a proper enactment clause attached to it or not, which then, of course, makes it no law at all. Which, just as a side note, I did a motion for someone recently. I think it was in Michigan. And it's a motion that basically says that all of the Michigan traffic laws are completely unlawful because none of them have a proper enactment clause, which my understanding is that no state traffic laws have a proper enactment clause established to them. So you can use this motion in any state, and it scares the shit out of them. They don't want to peer back there at all. They don't want to know what their masters are doing. They don't want to question what their masters are doing. They don't even want to question the fact that they might not be doing something lawful based upon what their masters told them to do. So there's all that fun stuff.
What would happen if you were to bring that up like in open court? I literally got the ticket and like immediately drove to the courthouse.
On your own volition, you're saying? Okay.
Yeah, because I was like, fuck you, I don't have time for this shit. So I literally went there and they were actually like, we're having court today. And, you know, because it was one of those things on the ticket.
So yes, the answer is yes, you could do that right then and there. Yes, you could.
Yeah, but I'm saying, like, if you were actually in open court and you actually mentioned that as an objection.
Because I've never thought about doing it verbally. So I would say objection, Your Honor. Does the prosecution have valid proof that they're willing to place upon the record of this court that the laws that they are charging my estate with have proper enactment clauses and are therefore law. Something like that. Now, I just that was just something off the top of my head, but you really wouldn't have to be any more specific than that, because it's a specific thing that you're asking for. And you could follow that up with, and Your Honor, if they fail in doing so, I move the court to enter an order to dismiss all charges in this case with prejudice. Right? You can do a verbal motion like that to move the court to get them to get rid of it, which the judge might very well do right then and there if you're bringing up that point. But that's more or less how I would say it verbally. So yeah, you could do it verbally.
How upset do you think they would be?
They'd either be really scared and just get you out of there immediately, or the judge might play stupid and they might be like, well, we don't know what you're talking about. What's an enactment clause? Like playing like super ignorant, right? Because they'll do that. And they'll also belittle you. And they'll say, well, what do you know about law? Objection, Your Honor, irrelevant. Ibid, meaning exactly what I just said. Like, I would repeat what I said. And sometimes you have to, the strange thing about maritime admiralty courts is that you have to repeat yourself 3 times, sort of. But there's a way around that too. You can get rid of it in one sentence by not having to repeat it 3 times. You can say the exact same thing that I just said, but in the beginning, you say, Your Honor, I thrice demand XYZ. And by simply saying thrice, meaning 3 times, it takes care of that technically. So you can kind of get around having to repeat yourself over and over and over. But so yeah. All right. So anything else?
Thing like in Islamic law, how in Islamic law, like if a wife really pisses off her husband, he'll be like, I divorce you. Don't make me say it a 3rd time. Because that's sort of...
I don't know if it's some Sharia law or Islamic law has the same kind of connections into maritime admiralty. If that is actually a thing, which I've never heard of.
Same place.
Okay, well then it all really stems back prior even to the Phoenician Canaanites. It really stems all the way back to Egypt, really, even prehistory. Where we get it from, our version of it, is really the laws of Oleron. But it probably has, particularly if you're saying that's something that they do or is in there, probably has an older center point, an older starting point that it has to be repeated 3 times. But yeah. Okay. So law said, I want to have 10 more babies and record not register they're being born, as should every founding stock in American woman of childbearing age. That's revolutionary. Yes, exactly. Never, ever, ever state the child's name when you're in the hospital. This just goes for anybody that goes to the hospital to have a child. Both the mother and the father, do yourself a favor. Never name the child. Never state the child's name. Never say, oh, Brian's so beautiful. Or, oh, Cindy, isn't she wonderful? Never, ever say the name in the foundling hospital, because every single room in every single foundling hospital is wired. And I could give you a story about that, but it's getting a little late. I'll save it for another time. Just trust me on that one. And Janice said, maxims of law exist from antiquity. Yep, proven themselves valid over and over, which is what I said. Corbett said, thanks for updating the timeline doc and the links provided. Yes, by the way, thank you very much for bringing those up today. What Corbett found was there were 2 links that were broken in the timeline doc. I fixed them, and then I re-uploaded it into the mega file. Now, if anybody finds any other broken links in any document of the Vocational Science for Freedom, never hesitate to simply email me and I'll fix it. And the email is vsof@protonmail.com. And I will be happy to fix anything that's wrong, because things change. In fact, what that was, or what one of them was a situation of which there was no longer able to be brought up the article from, I think it was Veterans Today, about the hidden history of the incredibly evil Khazarian mafia. So look, oops, page not found. Well, Veterans Today is still working. It's not as if Veterans Today went down. So what I had to do was I went into the Wayback Machine and I found it. Because guess what? It says the 100 most popular articles of all time. Guess what the first one is? This one. Well, then why can nobody read it? Yeah, I seriously doubt they're getting like DDoS attacked all day long. It's probably because either the service providers, the internet service providers, whoever you've got for your service provider, and the international Jewry has probably decided to go to all of the internet service providers and make sure that that link does not go through. That's probably what they're doing. But I don't care because I downloaded the whole entire document and I believe I put it into the mega file anyway. So you can either use the Wayback Machine to go look it up, or you can just download it from the mega file. All right, Klaus said, what are the maxims that fulfill law and bring justice? Oh, that's a loaded question. There's a lot of them. And maxims are derived from pretty much the jurisdiction upon which they were established within, meaning that some maxims have jurisdiction based upon the common law. Some maxims have jurisdiction based upon equity. Some maxims have jurisdiction based upon Roman civil law or ecclesiastical or military. It really depends. But the fact is that if it is a maxim and you find it, one place you can find an awful lot of them is in the backside of Black's 10th. I think Black's 9th also has a list. There's a lot of Blacks that have maxims. Also, there's under the definition of maxims in Bouvier's Law Dictionary, there is a lot of them, but they're not as specific as to like where they came from, where Black's is a little bit more of that. It gives you at least a better idea as to what jurisdiction and where they came from. So Jenna said, it's almost like perfectly natural. The people were literally born to do it. Yes. Meaning that you shouldn't have to register anything, which is the whole point of this. Once you register something under Roman civil law, you are splitting the title into equitable title and legal title. And those who own legal title actually own the thing, and those who have equitable title are the infants that get to play with it. Okay, so does anybody have any other questions or comments? Because now we're getting a little bit past time here. And if not, that's all good. And this has been the last and final reading of, again, this Zerohedge article. I hope all you guys enjoyed it. And if you have any other extra questions, you can always ask them on the Vocational Science Freedom Revolt server. And again, just go to vocationalsciencefreedom.wordpress.com, download the welcome package, and set up your comms, and submit it back to me at VSOF@protonmail.com. And I'll let you into the Revolt server and let you into the mega classroom, and where we have our Wednesday night roundtables as well. So thank you all for coming. I'll see all you guys on Wednesday night for our roundtable. And until that time, as always, stay safe, stay sovereign.